judgment in the matters of the Attorney General against the Jamaican Bar Association and the General Legal Counsel against the Jamaican Bar Association.
In these proceedings, the Jamaica Bar Association, which represents the interests of attorneys, complains that the extension to attorneys of certain aspects of the Jamaican anti-money laundering regime interferes with the guaranteed constitutional rights of attorneys and, more importantly, the rights of their clients. Rights, that is, to privacy, to liberty, and to protection from search of property. The two aspects of the extended regime of which complaint is made are, first, the conferring on the General Legal Counsel, the regulator of attorneys, of a regulatory power to monitor compliance by attorneys with the regime, including by periodic inspections of attorneys' files and by information sharing with other authorities, and secondly, the imposition upon attorneys of a duty to disclose suspicious transactions to the Financial Investigation Division of the Ministry of Finance and Planning, with a corresponding prohibition of tipping off clients and others suspected of money laundering. The Jamaican Constitution protects rights to privacy. The protected rights include attorney-client confidentiality, under which attorneys are under a duty to their clients to keep confidential the information received by them in the course of working for their clients. It also includes legal professional privilege, under which attorneys must withhold from disclosure information, including documents, arising from the giving of legal advice or from the conduct of litigation, unless their clients consent to disclosure. Constitutional rights of this kind may only be invaded by the state if the interference is demonstrably justified in a free and democratic society. The Jamaica Bar Association's complaint was rejected by a three-judge panel of the Supreme Court of Jamaica, sitting as a constitutional court. But the Court of Appeal upheld the complaint in part on the basis of the invasion of privacy, liberty, and freedom from search, in each case without demonstrable justification. On appeal to the Privy Council by the General Legal Counsel and the Attorney General, the Board has decided unanimously that the Jamaican Supreme Court was right to reject the Bar Association's claim. Lord Hamblin and I give the opinion of the Board. Our reasons are in summary as follows. 1. It has been common ground throughout this litigation that the anti-money laundering regime does invade attorney-client confidentiality to a significant extent. But in the Board's view, this invasion is demonstrably justified. Attorney-client confidentiality is commonly invaded, for example, during the process of disclosure in civil litigation, where the justification is that it enables the court to do better justice by coming at the truth. Here, the provisions in the anti-money laundering regime, now extended to attorneys, serve an important public purpose in combating money laundering, which is itself a serious threat to the rule of law and to economic prosperity in Jamaica. The evidence shows that there is a real risk of the services of attorneys being used by money launderers, and that the extension of the regulatory and reporting regime to attorneys is both rational and sufficiently connected with the anti-money laundering objective. Furthermore, although some countries apply only civil sanctions for breach of a similar regime, others impose criminal sanctions, and their imposition in Jamaica was within the range of options reasonably open to the Jamaican Parliament. By contrast, the regime does not invade the much more important right of privacy embodied in legal professional privilege. That privilege exists so as to enable citizens to obtain reliable legal advice from attorneys and to have proper access to justice by using the services of attorneys in legal proceedings. The powers of the General Legal Counsel to inspect attorneys' files are carefully framed in the legislation so as to exclude access to privileged material. The process of routine inspection by the Council is structured in a way that enables attorneys to act as effective gatekeepers of their clients' privilege. The Council will be obliged to return any privileged material inadvertently disclosed, and there is no reason why the courts would not be able to rule upon any dispute as to whether particular material was or was not privileged. Similarly, the provisions of the regime which require attorneys to report suspected money laundering to the Financial Investigations Division expressly exclude suspicion arising from privileged material, and the prohibition against tipping off is framed so as not to prevent an attorney taking specialist and privileged legal advice, if needed, about whether a reporting obligation has arisen. The regime does not invade any constitutional right to liberty. The only restriction upon liberty arises from the sanctions, which include penal sanctions and disbarment, which could flow from a breach by an attorney of the requirements of the regime. Provided that those requirements are themselves not unconstitutional, and the board considers that they are not, then a restriction upon liberty as a sanction for breach of them cannot of itself be an unjustified interference with the constitutional right to liberty. Finally, the regime imposes no unconstitutional interference with freedom from search of property. The regulatory role of the General Legal Counsel in conducting periodic inspections of attorneys' files does not include a power to enter attorneys' premises or search attorneys' files without their consent, without at least first obtaining a search and seizure warrant from a judge under detailed statutory conditions which rule out arbitrary use. Accordingly, the board will humbly advise His Majesty that this appeal be allowed and the judgment of the Jamaican Constitutional Court restored. The hearing is now adjourned.